Again, Attorney Steve Vondran, and welcome back to the Litigation War Room. Okay, so we are licensed practice law in California and Arizona. We take federal copyright cases nationwide, subject to local court rules. Okay, so this is general legal information only and not legal advice. This is a very important video. If you are a Doe defendant, you're a defendant in a John Doe Malibu Media lawsuit where Malibu Media has sued you for downloading adult pornographic films. Okay, so this is a case that was filed up in the Northern District of California. That's in the northern part of California, up in the Bay Area. I have more information about the 9th District. If you want to find out more about that, Google Attorney Steve 9th District. Okay, what is it? So, but anyway, this was a case that was filed alleging 131 movie downloads. That's quite a bit. The penalties on that can get quite high. Okay, so that could be a pretty high infringement penalty, pretty high settlement value. So in this case, and I'll give you the reference real quick, by the way, if you want to look that up. This is case number 3:16-CV, Charles Victor, -01006. This is Judge Alsop, okay? This is, again, motion to quash subpoena. So the plaintiff went ahead, filed the complaint, filed the motion for early discovery, asking the court, I want to serve a subpoena on the internet service provider. Okay, the internet service provider is AT&T, Comcast, Verizon, all those. Okay, so they wanted to get the name and the identity and maybe some other information from the internet service provider so they could find out who to name on the lawsuit, on the John Doe lawsuit. So they had sought early discovery, and the court granted the early discovery and granted the right to serve a subpoena subject to a protective order. Now, the protective order said basically that if the plaintiff is going to get this information from your service provider, and if there's any documents that are going to be filed with the court, in other words, if they were going to amend the complaint and add the name of the Doe defendant, then they need to file that under seal. So there was a protective order there designed to protect the privacy of the internet service provider because, let's face it, maybe the subscriber is not the same person who downloaded the movie, right? It's very possible. I could subscribe to Comcast and maybe somebody in my household is downloading the movies, or somebody's visiting, sharing on my wireless, they're downloading the movie. Well, that will show as my IP address. And then, of course, I'm getting sued for something I didn't do. So in this case, the defendant retained counsel because, like I said, I think that's going to be quite a bit of liability. Retained counsel, and they filed a motion to quash the subpoena. And the essential grounds on the motion to quash the subpoena, there were 4 essential grounds. One is the defendant has the standing to challenge. That means I have the right to make this challenge. And that the subpoena would subject the defendant to an undue burden, annoyance, and/or embarrassment. 3, that the plaintiff's subpoena will not actually identify the alleged infringer. And 4, that the plaintiff failed to establish jurisdiction. They did not give sufficient details as to this geolocation technology and the reliability of the technology so that the court knew that it has the right to exercise jurisdiction over the defendant. Because again, they're just going on an IP address and some third party that's saying, hey judge, yeah, that's the defendant lives up in your jurisdiction. They live in San Francisco. So those were the main grounds. Again, that was kind of the procedural order. Now, so this was a Rule 45 motion to quash. We have more information if you want to know the grounds for motion to quash, when you can file it. You know, we have a video out, Google Attorney Steve motion to quash. At the end of the day, Malibu Media did not appear at the hearing on the motion. So the court went ahead, reviewed the briefing papers, the documents, the cases cited by the defendant, which were numerous, and some of the other rationale that was provided, some of the arguments. And the court basically said, I'm not going to allow you to serve the subpoena. It is stayed. The subpoena is stayed. So this is an order staying compliance with third-party subpoena. So the court noted that Malibu Media is essentially had filed 178 copyright infringement actions in this district. That means 178 cases in the Northern District of California. So that's quite a few. The bottom line is the court mentioned that Malibu Media hired Excipio GmbH, which utilized the BitTorrent protocol to download several of Malibu Media's files from the internet. Excipio monitored the IP addresses of the distributors of each piece of each file it received. However, the court said no declaration was provided explaining the use of geotechnology to ascertain the approximate location of the IP address. So in other words, the court was saying, I granted the early discovery. There was nobody challenging that. When they seek the motion for early discovery, there's no opposition because the defendant doesn't know he's being named yet. That hasn't been identified. So the court said, there was no declaration to support it. Well, now it's being challenged. So the defense attorney came in, made the challenge, and the court basically said, you have to provide a declaration, a sworn declaration, as to the reliability of the geotechnology, geolocation technology. If not, the court cannot be certain that it has jurisdiction. And the federal courts don't want to waste their time exercising jurisdiction if there's not some reliable means to determine that the defendant actually resides in the jurisdiction. So that was really the essential holding of the case from the judge also. And the other arguments were essentially shot down. The court argued, no, that's not really an undue burden. It's your privacy is protected with my protective order. So that was kind of shot down. The court denied the argument that, serving the subpoena and providing the information of the subscriber will not likely identify the wrongdoer. And the court said, hey, well, maybe it won't, but maybe it does. It may lead to that. So the court basically said, that somebody could be identified and serving the subpoena is the best way to do it. So that argument was kind of shot down, but the winner was actually the geolocation technology argument. This is why you make your arguments that you think might apply. And the court says Malibu Media does not address its failure to provide a sworn record, that's your declaration, your affidavit, of its geolocation process, but rather submits only an attorney argument asserting that its geolocation services are accurate. So what the court was sort of inviting was to file a declaration sworn with sufficient details as to the reliability of the geolocation technology so that they could actually place the defendant in this jurisdiction. As the court noted, as such, its motion should have been supported by sworn evidence of such a critical fact as the means for determining the location of the accused infringer. This serves not only to protect the subscriber from the threat of litigation in an improper venue, but also to ensure that the relief sought does not require the court to exercise authority outside its jurisdiction. So they don't want to waste their time. The court said this would come at a negligible burden, a minor burden to the defendant or to the plaintiff, Malibu Media. So they just get a reliable declaration. So at any rate, the court didn't sort of foreclose the notion that a declaration could be filed or that this could have been remedied. But point is, it didn't happen at the end of the day. If you look at the court's docket, this case ended up in a voluntary dismissal. So whether that means settlement or not, I'll leave it to you to guess. But one other point in here, the court did also talk about static versus dynamic, because sometimes when you have an IP address, businesses have a static IP address, meaning it doesn't change, whereas a residential, like my house, my office, so forth and so on, that may have a dynamic, so it's always changing. So the court addressed that, while these numbers are changing, give me something from your third-party expert. I don't want hearsay from the attorney. I don't want the attorney saying what he thinks the third-party investigator is going to say. They want a sworn declaration from the actual investigator. But that may also need to be addressed. So these are some very important facts if you find yourself facing a Malibu Media case. I'm not saying a motion to quash is proper in all cases. This is something that you need to discuss with your legal counsel, but certainly it can be a tool in your toolbox when you're fighting this company, Malibu Media, who is filing a lot of lawsuits. So if you need some help with a BitTorrent or a illegal movie download case, Malibu Media, London Has Fallen, Me Too Productions, Cell Film, whatever the films may be, give us a ring. We're happy to give you a free initial consultation to discuss the pros and cons and what typical settlements might look like. But give us a call. You can find out more information about our services at torrentdefenders.com. That's torrentdefenders.com. I hope you've appreciated this, a little bit of insight. I hope it's been helpful. Again, this is not legal information. This is not legal advice. This is legal information, general legal information. Okay, Attorney Steve, you can find me at attorneysteve.com. Thanks for watching. If you enjoyed this video, feel free to share it on your social media networks. If you got some comments, place them down below. I'll see. I'm real busy. Might be able to get to them, might not. But again, appreciate you guys watching, and thanks for joining. Don't forget to subscribe to our channel. Okay, I got to get running. Got lots of work to do. We'll see you later.